to be a great day for us to all get tapped into what we need to do to fight for our Constitution. Our next speaker is Susan Shelley. Susan is the author of 3 books on the Constitution. 37th Amendment is one of them, and feel free to talk about the other ones, Susan, when you begin. She writes op-eds and blogs on issues related to the Constitution. In 2012, she ran for Congress, and then again in 2013 for the California Assembly, and she came within 329 votes of winning. And recently,
voter fraud.
Thank you.
Recently announced that she is running again for the California Assembly.
All right.
And so you need to make note of the name Susan Shelley for the June primary and the November election, and tell your neighbors that she supports the Constitution, as you're about to hear.
Excellent.
And let's all welcome Susan Shelley.
They want to know her district. They want to know her district. They want to know your district.
District 45 in the West San Fernando Valley. I want to stay out of the shadow here of the light.
45.
Yeah. Just to have it ready.
Yeah.
Well, let me tell you a little bit about how I came to learn about the Constitution. I was a history major in college. I went to Cal State Northridge, and I was working in the television industry, minding my own business, and one day I got an idea to write a novel about crime. I thought, what would happen, hypothetically, just an idea for a novel, what would happen if you could change something in the Constitution to make the streets completely safe? What if you could? And you took the story 40 years forward to see how it turned out. And you asked, would the people of the future want to keep it that way? Or would they want to go back to the way we do it? And it was just an idea for a novel. And I wasn't really, I didn't know anything about the Constitution other than what I had learned in high school civics, and I just started writing the detective story part of the story about how the characters were going to interact and what the plot was going to be. And I figured I'll come back to the legal stuff. I'll do if I get this far, I'll do the legal research. I'm not going to do the legal research if I can't really write the novel. So I started the novel. I did 2 drafts with a lot of blanks in it. And this is where the legal gobbledygook goes, okay. So I come back to it. I put about a year or 2 into it, and I come back to it, and I've gotten to the point where it's time to start the legal gobbledygook. So I went to the Barnes & Noble or Amazon website, and I searched for books on due process of law, because it seemed like the logical place to start was, let's repeal, hypothetically, fictionally, let's repeal due process of law and make the streets completely safe with this draconian law enforcement, and that will get the story going. The story, I got the books, I opened the box, it wasn't 2 days, the whole premise of the novel fell apart. Why? Because everything was done through the Due Process Clause. You would not believe the things that were done through the Due Process Clause. Civil rights, women's rights, incorporating the entire Bill of Rights and making it apply to the states. I didn't believe it. I didn't believe it. And I started a parallel detective story myself, looking into the history, because as a history student, I was digging into the footnotes and I was saying, I don't believe it. I want to read the newspaper article that they're citing right here. And I tore into this book by Raoul Berger called Government by Judiciary. If you really are wonky about the Constitution, it's a lot of fun to read Government by Judiciary. Get the 2nd edition where he answers all his critics, because there were a lot of critics for what he wrote. It became like a detective story. How did this happen? How did the courts do this? How did they change it? When did it change? I was remembering the show Dragnet, which I used to watch in reruns, and I remember those scenes where a criminal would get off, and Jack Webb and Harry Morgan would look at each other and they'd shake their heads, technicality. What changed? What changed from when those characters started in law enforcement to that 1960s period where they were shaking their heads? What exactly was it? And I found it, and I didn't believe it. So I kept researching. I ended up doing 6 or 7 years of research deeply into the history of the Bill of Rights and what had been changed and all the Supreme Court decisions and the dissents to the Supreme Court decisions as it went forward. Because I'm not a lawyer. I was looking at how the lawyers were arguing. Where were they disagreeing? What had happened? And what are the consequences for us? One day I'm watching C-SPAN, and Justice Scalia is talking to a classroom full of students, or a Heritage Foundation or some group of Cato Institute maybe, and they were very They were asking surly questions, and then there was one really good question. One student said, what are the problems with a return to strict construction? And this was Justice Scalia's answer. I'm not a strict constructionist. I'm not. I believe that the Constitution should not be interpreted strictly or loosely. It should be interpreted reasonably. And he said,
His reasonably.
this is Justice Scalia. This is a conservative. I was really startled to hear this, but I knew what he was talking about because I had found it. So I listened to what he said. He said the biggest stretch the court has made. You want to talk about the problems with going back to strict construction? The biggest stretch the court has made is applying the Bill of Rights to the states. But it's not a problem. We've been doing this for 50 years, he says. We just take the same rules that I use to apply to the federal government. I apply it to the states. The public has gotten used to it. I'm certainly not going to tell the people of New York State or any state that the First Amendment does not apply to their state government. This is what Justice Scalia said. It's on C-SPAN. I'll give you the link. Here's what he's talking about. He's talking about the incorporation of the Bill of Rights. And I'm going to show you why we can't go back to strict construction. And I'm going to show you why it's our fault. It's the fault of the American people.
Yep.
It's easy to blame the judges.
There you go.
Wait till I show you what we didn't do in the 18th century. In the 19th century, rather, excuse me. Let's go to the first slide here. This is the First Amendment. The First Amendment did not apply to the states until 1925. There was a Supreme Court decision that said freedom of speech probably might be one of the liberties that's sort of included in the 14th Amendment. This was dicta. It was buried in the decision someplace. It wasn't really part of the ruling, but it had an influence on future rulings. 1925, the Gitlow versus New York decision, if you ever want to look it up. That's when freedom of speech first applied to the states. In 1922, just 3 years earlier, in a case called Prudential Insurance Company versus Cheek. I'm giving you these footnotes because I didn't believe it either, and I looked them up. Prudential Insurance Company versus Cheek. The Supreme Court said that the First Amendment does not apply to the states. 1922. I couldn't believe it. So 1925, they incorporated freedom of speech. They said, you know, this is really one of the liberties that the 14th Amendment says you have to apply to the states because the states are prohibited from denying liberty to any person. This is such a fundamental right, freedom of speech. How could they not have meant? But I ask you just for a moment, if the framers of the 14th Amendment had meant that, why was it that the Supreme Court didn't realize this till everyone who voted on it was dead? Just bear that in mind as we go forward. I'm not arguing with the decision that they made or the result. Let me make that really clear because I'm a candidate for office and I don't want you to think I'm not for freedom of speech. Of course I am. I just am interested in when did this change, who changed it, and what are the consequences. So let me go quickly through this. Freedom of speech was incorporated in 1925, freedom of the press in 1931, freedom of assembly in 1937, the free exercise, 1940, and the establishment of religion, the prohibition on the establishment of religion, that did not apply to the states until 1947. 1947. Okay. So Justice Scalia says it's not a problem. He just applies things as he would to the federal government, to the states. Here are some of the consequences, and you can decide for yourself as citizens whether you think it's a problem or not. Do you remember when California passed that ban on selling violent video games to children? And the Supreme Court threw it out. The standard was, under the incorporation theory that they've constructed over the 20th century and beyond, is there a compelling reason to infringe a fundamental right? Is there a compelling reason? Not a rational reason. A rational reason isn't good enough to infringe freedom of speech. You have to have a compelling reason. And Justice Scalia didn't feel that California made a compelling case that violent video games are damaging to children. It might be the opinion of the lawmakers that it does, but it's not compelling enough for whatever the ruling was, 5-4, 6-3, whatever the ruling was. The justices felt that they were going to strike down that law. The people of California could not have that law. In New York, there was a law regarding pornography on library computers. And there was some, they were having like a peep show problem where people were going to libraries and watching porn in front of kids in the line checking out school books or whatever, and
No, the kids were looking at the porn, is what I was saying.
no, but they were maybe, but they were
the high school.
no, they were trying to keep the kids away from the porn, but adults had a constitutional right. This is what the librarians decided. They had a constitutional right to view legal material in a public library, and there was no right. They said if the state had passed a law trying to ban porn in libraries, they would have been sued in federal court, and they would have been, and it would have gone for years, and they probably would have lost unless they could convince the judges that there was a compelling reason to ban it, to violate the First Amendment right. So this is the standard: compelling or rational. Is it a fundamental right, or is it just a basic right? As Mr. Neely was talking about, is it a non-fundamental right? This is not a distinction that the framers put in the Constitution. The judges made this up in the 20th century. One thing that we saw recently, talking about how we have to defend, this is a little off the incorporation subject, but the Critical Information Needs Survey, you heard about this, where the FCC was going to put people in newsrooms?
Oh,
Yeah.
right.
Was that alarming, or was that
Yeah.
alarming?
Yeah.
Internet too.
And now, fortunately, the FCC has pulled it back, and we didn't have to go to
For now.
court to say,
Yeah.
for now, exactly. They did it on their
It's a
own,
global watch
on their
now.
own say-so, so they could probably pick it up again.
Right.
They didn't get a court ruling saying they couldn't do it,
Right.
but they can't do it. The federal government has no authority to regulate the content of speech, and they have no authority to investigate the content of speech. And that's that. So this is an example of public outcry. This is how you stop these abuses. Public outcry, writing op-eds, as one of the FCC commissioners did in the Wall Street Journal, to call attention to this and say, no, no. Usually that's all it takes to stop it, is everybody just saying, no. Sometimes you can go to court and you can't get any satisfaction because it takes too long and the problem continues, and anyway, so onward. Go to the next slide. This is the Second Amendment. Some of this was already covered. The Second Amendment, the Heller decision, established that there is an individual right to own a gun, and then it was the McDonald decision in 2010 that applied it to the states and made it incorporated. And once again, you've got this fundamental versus compelling thing. Had they said it was not incorporated, then it would have been up to each state whether they were going to have gun control or not. And the gun rights groups could have fought at every state legislature to protect gun rights. This way, the federal judges are in charge of it. And we just saw in San Diego, the Ninth Circuit Court threw out their law that was restricting concealed carry permits. And the people in San Diego decided they're not going to challenge that ruling. They're just going to let it go. And the California Attorney General has petitioned the court to be allowed to enter the case and argue on behalf of gun restrictions. And it's all going to depend on who hears the case and whether they think the need is compelling or not compelling for the law. Do you want to hold your questions? I might answer as we go. Hold the questions. Okay. So that's what the incorporation doctrine does. It creates a situation where the federal courts decide whether the state laws will be allowed to stand or not. So in the broad spectrum of this, what has happened is powers that used to belong to the states now belong to the federal courts.
Yep.
And you wind up with one gun control law being upheld or thrown out 5-4 in the Supreme Court. That's the new standard for the whole country. We have this, for instance, with another First Amendment example is topless dancing in bars. Topless dancers have a free speech right unless the state can show a compelling reason that this is causing problems, and that's why in order to get a topless bar shut down, citizen groups have to go around and they have to prove there's drug use or prostitution or car break-ins or something compelling to ban whatever's going on in the club. Otherwise, there's a First Amendment right. And this is something that they create these balancing tests. The judges create the balancing tests, and they do the balancing, and the local people have lost the ability to control these kinds of laws, which they used to have. And wherever you come down on the issue, it's a question of who decides what it's going to be. The people through their elected officials, or the federal courts from the top down. And you can make an argument that you might get a good result or a result that you agree with, or a result that you don't disagree with, that doesn't make the process correct. So, okay, go to the next slide. This is the Third Amendment. I'm unaware of anyone violating the Third Amendment anywhere, so we'll skip that one. The Fourth Amendment. Oh, my slide got messed up. Sorry about that. Let's talk about the NSA for just a second. Secure in their persons, houses, papers, and effects against unreasonable searches and seizures. That's what it says.
Yep.
The federal government can't do what it's doing.
Nope.
The NSA, this NSA collection of phone data and retention of phone data is just flat out unconstitutional.
And email.
And email. It's whatever they're collecting, whatever they're searching through without probable cause, without a warrant, they can't do it. And we really should stand up against this. We really have to. Because they're doing this in secret. We're not going to find out that it's abused. We're not going to find out that there's any kind of misuse because it's all secret.
But it's for terrorism.
Well, you know
For our own
what?
good.
See, this is how people lose their freedom.
Yep.
This is very serious. This is really very serious stuff because it's always something. It's always something. It was the Cold War, it was World War II, it was World War I, it was the Civil War. It's always something. There's always a reason for the government to keep you safe by taking your rights away.
Nope.
And we have to stand up to
You
it.
give up your
We
liberty
have
for
to-
safety.
Exactly. We have to stand up.
Same with
This
TSA.
is reasonable. Reasonable is the word, and it leaves room for emergencies. It leaves room for the World Trade Center was attacked this morning, so this afternoon we're holding everybody till we know what happened. It leaves room for that. Reasonable. And retaining the data forever is not reasonable. And just this week, on Friday, there was a decision. The Justice Department had petitioned the Foreign Intelligence Surveillance Court to keep the data forever, the phone data, forever. They said, well, we might need it in, there are these civil suits, people are suing us over this, and we might need this data forever for the civil suit. And apparently the current law says 5 years. And the judge said, okay, that's it. You can have the 5 years and no further. You can't have the permanent extension. Now the whole thing is probably going to fall if it's challenged and the courts hear it. But the courts have a lot of discretion over what they hear.
Well, they ignore it.
And they can ignore it.
Like Holder ignores.
Which is why it's so important for citizens to be aware and to call their politicians and say, this can't continue. This can't continue. Because there's always going to be a threat of something. Terrorism's a very scary thing. Lots of things are scary. Losing your freedom is scary.
I'm more scared of that.
Exactly, and rightly
And
so.
Obama.
So on the, let me go back to the incorporation doctrine for a second. Let's stay here for just a second. The right to, the Fourth Amendment right, you heard of the, of evidence being excluded in trials. Well, that didn't used to apply to the states. That became applicable to the states, I believe, in the Mapp versus Ohio decision, which I think was 1961. So it was up to the local officials and the local elected officials and the local police prior to 1961. It was up to them whether evidence was going to be heard or not. It was up to the local courts. Let me find that for you. Hang on. Yes, the exclusionary rule was incorporated in Mapp versus Ohio in 1961. And it's commonly thought that you have the right to a jury trial in all criminal cases. That also is from the 1960s. That was not a federal constitutional right until the 1960s. That was, let's see. Oh, and the Fifth Amendment right, the next one. The famous Fifth Amendment right that we heard about from the
Lois Lerner.
from Lois Lerner, thank you.
She was on the FCC.
So this is the federal government, of course, that she's
the-
talking about. But in a state trial,
voter fraud.
you did not have that until, let me see, Malloy versus Hogan in 1964. And the Miranda warnings, that's from 1966. So these were the Jack Webb decisions. They had him shaking his head. This is what Justice Scalia meant when he said we've been doing this for 50 years. A lot of this goes to the 40s, the 50s, and the 60s, incorporating all of these rights. And then that creates this situation where the justices decide whether the state has a compelling reason to search, the police have a compelling reason to search. Can they search for drugs? Can they search for drunk drivers? When can they? It's all up to the courts, and it's anybody's guess, because what is compelling to one judge may be only rational to another judge. There's a very thin line there. And justices throughout the years have been complaining that this is purely subjective. Did you see that case? Let's go back to the First Amendment for just a second. Did you see that case where a court said that a school was allowed to send children home for wearing an American flag shirt?
Yes.
Yes.
Here in California.
Yes,
Right.
in
Yeah, of
California,
course.
that they did not have a right, the children did not
To
have a
wear.
free speech right to wear a flag shirt on Cinco de Mayo.
Yeah, San Jose, I think.
Yeah, I
Amazing.
remember that.
This is based on the Tinker decision, Tinker versus Des Moines School District, 1969, which had the kids came to school in armbands to protest the Vietnam War, and there was an argument over whether the school could ban the armbands. The school banned the armbands, and the court said in a divided decision that violates the students' freedom of speech. Now, Justice Hugo Black, who was 82 years old at the time, just about to turn 83, got so angry at this decision, he wrote this blistering dissent that said control of the schools is being seized by the courts with this decision. But what the decision said is that if the school officials had a real concern that there was violence, then they could ban the armbands. And then they had this argument over whether there was a legitimate concern for violence or not. And what we just saw with the American flag shirt decision is the school said there will be violence between this gang and that gang, or this gang and these students. And we can't have this kind of violence, so the American flag shirts are banned in an American school on Cinco de Mayo. That's kind of a disturbing decision.
Yeah.
And it's coming from the courts down to the schools. It's not coming from the school board or the parents, it's coming from the courts. So wherever you are on the decision, the who decides question, I think, is very important. And the consent of the governed was never given for the courts to monitor all of our state laws this way. And I'm going to show you why we're stuck with it. Okay, let's go on to the Sixth Amendment. The jury trial, I think, is 1967. It's incorporated. Second. Forgive me for not having this committed to memory. Klopfer versus North Carolina, 1967. The right to a speedy trial, the right to a public trial, 1948. Trial by impartial jury, Duncan versus Louisiana, 1968. You haven't had a federal constitutional right to a jury trial except since 1968. It was a state right before that, but not a federal right. So this is what Justice Scalia was referring to. We've been doing this for 50 years. And who's we?
Yeah.
Who's we? The Supreme Court, not us. This is not something that we've ever run through a state legislature or Congress or put before the voters. This is something that was completely developed by the judiciary, and no one even knows about it. No one even realizes why these decisions are so unpredictable. Like the gun control decision, now that it's an incorporated right, it's completely unpredictable. It all depends on who's on the bench.
Yes.
It all depends on who's elected president and who's on the bench. And you can, if you ever doubt that the courts have become legislators through this doctrine, just take a look at the last paragraph of any news article about a Supreme Court decision. What does it tell you? It tells you who appointed the judges. Well, there's 2 Clinton appointees and a Bush appointee. This one's a Reagan appointee. And why are they telling you that?
But Roberts.
But they're telling you because what they're doing is legislating, what they're doing is political, and it seems relevant to the journalists who appointed them. So they always tell you that. And the other way you can tell that this has become completely subjective is when one of the Supreme Court justices retires, all heck breaks loose.
Yeah, that's scary.
And people start talking about civil rights could be rolled back. Well, why could civil rights be rolled back? Why? Does anyone ever explain why? Why is it that when the health care bill was being debated and people said this is an overreach of power by the federal government, liberals jumped up and said, I suppose you're against Brown versus Board of Education. Who was talking about Brown versus Board of Education? We were talking about health care. Federal overreach. And now we're going to get to it. Go to the next. Let me show you. Next. Oh, let me stop here. Let me stop at Go back to the Eighth Amendment. Here we go. Cruel and unusual punishments. Robinson versus California, 1962. Before 1962, the federal courts had not applied this provision to the states. Right now, California is releasing felons because the federal courts have ordered us to do it based on violating this clause of the Eighth Amendment. Prior to 1962, they couldn't have done that because it didn't apply to the states. So I just wanted to call to your attention that the reason California is in that situation, and once again, when they ruled on that prisoner release, there was a huge fight in the court about it. I believe it was Samuel Alito who said that the court was being way too cavalier about the harm that would happen from releasing felons early to relieve prison overcrowding. And the justices were not taking that into account in his view. But he was outvoted. And I just want to call to your attention, 1962. Okay, go on. This was put, the Ninth Amendment, you had that question earlier about whether the Ninth Amendment creates a right to welfare and right to health care. The purpose of the Ninth Amendment was a lot of people didn't think we needed a Bill of Rights, including James Madison at the time. He didn't think so, because they felt that the federal government only had the powers delegated to it. Why say that there's no power to do something which there's no power to do?
Exactly.
Why do that? And this was the compromise position. They said, all right, we're going to state that we don't mean that only these rights are the ones that exist. All other rights exist. Nothing in this list should be interpreted to mean that there's nothing else on the list. So that was the backstory on the Ninth Amendment. It certainly never had anything to do with creating the right to, as Mr. Neely said, material support. Okay, go to the 10th Amendment. This is one more. This was to protect the states, because the fear was, at the time of the founding, the states were first, of course, and the Constitution was second, and the states were fearful that the federal government would exceed its powers, rightly so as it turns out, but they put this in to say they can't. We really mean it. They can't. We've limited their powers to what's enumerated. We've stated these extra rights that we absolutely mean it for sure we don't want infringed, and you can't do anything that's not in the listed powers. Everything else is reserved to the states. And as we know, that's completely ignored. The justices have replaced this with the incorporation doctrine, and they now run the states effectively from the federal bench because of this interpretation. And let me show you why we're stuck with it. Go forward. Okay, this is what we were talking about before. This is the clause, the due process clause of the 14th Amendment that says, no state shall deprive any person of life, liberty, or property without due process of law. But let me show you what wasn't in the 14th Amendment. The next slide. One more beyond that? Okay. There shall be no discrimination in civil rights or immunities among the inhabitants of any state or territory of the United States on account of race, color, or previous condition of slavery. This was the first section of the Civil Rights Act, the Civil Rights Bill of 1866, right after the Civil War. This was in there. And they took it out. They took it out. It was the middle of the 19th century, and they didn't have the votes for this. This was in committee. All laws, state or national, shall operate impartially and equally on all persons without regard to color or race. Never made it out of committee. This has never been added to the Constitution, and this is why we can't go back to strict construction. Everything that was done for civil rights, which we cannot risk and we cannot lose, was done through the Due Process Clause and the Equal Protection Clause through an interpretation by the federal courts. They rescued us from the racism of the 1860s.
The Democrats.
The Democrats, right.
The Democrats' racism, that's right, because it was the Republicans that were, this was Thaddeus Stevens of Pennsylvania who proposed this in committee, but it never got out, I think it never got out of subcommittee. They did not have the votes in 1866 for this. We have never amended the Constitution to ban discrimination. And this is why everything is equivocating when the Supreme Court reviews anything having to do with race or affirmative action types of things. It could go either way, because discrimination never was actually textually banned. in our country. This is our missing amendment. This is why it's our fault that the judiciary is activist. If they weren't activist, we would still have what we had prior to Brown versus Board of Education. In all likelihood, maybe we wouldn't have. I mean, maybe the votes would have been there had the court not jumped in at Brown versus Board of Education and desegregated the schools and all the rest of the civil rights law. Perhaps the society would have changed and the laws would have changed the constitutional way. But they jumped in, I think rightly so, because slavery was a particularly different kind of violation. We've had lots of discrimination against lots of different groups in our history, but slavery made people into property. And the Constitution protects property rights as the foundation of freedom. Because if people can take your property, then you're not really free. Okay? So if you allow people to be property, the whole structure of the Constitution is flawed. People cannot be property. And that's why the legacy of slavery needed the courts to correct. It was a whole different category of problems than what you have from the bias against any other group, without going through the list of all the groups that have had all these terrible laws passed against them. The segregation laws were worse in that sense because they were a structural flaw in the Constitution, a structural flaw. We've never done this. We've never amended the Constitution to ban discrimination on the basis of race and, for what it's worth, on the basis of gender. The Equal Rights Amendment, which was proposed in the 1970s, didn't pass, and women's rights have been done through the same interpretation. There's federal law, there's state law, but where is it anchored in the Constitution? Through an interpretation. And this is why, when someone like Sandra Day O'Connor retired, you get this panic in the press. Women's rights will be rolled back, civil rights will be rolled back. Nobody's rolling anything back. But technically, it's possible, because it was all done through an interpretation. And this is what we have never corrected. Go to the next slide. This is another missing amendment. This was proposed in the original list of the Bill of Rights by James Madison. There were 12. This one never made it. This was killed in the Senate. No state shall violate the equal rights of conscience or the freedom of the press or trial by jury in criminal cases. Here again, the court stepped in. 1968 for Duncan versus Louisiana for the trial by jury in criminal cases. Madison wanted this in 1791, and he couldn't get it through the Senate. We've never done this. We have never passed an amendment to the Constitution saying the Bill of Rights applies to the states. We've never done it. So it's all subjective in the courts. It's a huge mess. Everything now depends on who appoints the judges, which is not the deal we signed.
Just real quick, who would be the people or the group that would bring this to become an amendment?
Well, funny you should ask.
I'll do it. Tell me how.
Funny you should ask. Go to the next
ready.
slide. Okay, this is Article 5 of the Constitution. This is the
Campaign for her
procedure.
and then you do it.
This
Yeah,
is the
okay.
procedure for amending the Constitution. Now, there's two ways that they gave us to do it. One is through the Congress, and one is if the Congress is the problem, there's another way around them. So here you go. It takes a 2/3 vote in the House and a 2/3 vote in the Senate, and then it goes out to the states for ratification, and it takes ratification by 3/4 of the states, and then it's as much a part of the Constitution as if James Madison wrote it personally.
Susan, is this what Mark Levin is
Yeah,
pushing?
that's
I
it.
believe so.
Okay.
Yeah.
And this constitutional convention, he's talking about this legislative convention.
Right.
The way around it, if Congress is the problem,
Yeah.
then all of the state legislatures can petition for a constitutional convention
Yeah.
for the purpose
Get his
of,
book.
it can be limited, for the purpose of passing amendments.
Do we have
That's
3/4 of the states right now with the legislatures?
What do you mean, do we have 3/4 for what?
Of the several states to go around the Congress and
We're
the
close.
Senate?
I think we're
Yeah.
close.
Yeah,
Well, it
we're
depends on
We
what you
were-
want, it depends on what you want to do. I don't think
Well-
you'd be able to, this is not designed for calling a constitutional convention and rewriting the whole thing. This is designed for a specific proposal where you would, suppose you wanted to do the anti-discrimination amendment that didn't make it through in
That's what I mean.
1966. Suppose you just wanted to do that one. There shall be no discrimination on the basis of race, just the way Thaddeus Stevens wrote it at the time of the 14th Amendment. That was supposed to be in the 14th Amendment, he wanted it there, didn't have the votes. Okay, let's say we wanted to do it now.
Yeah.
We wanted to correct it. Well, can you imagine proposing it? Who would oppose it? Wouldn't that be interesting?
California.
Yep.
It'd be an interesting argument to have.
Washington.
So
State.
if you
That's what I'm
proposed
saying.
it in
We
the
have
House
the
and the
three
Senate and they
quarters.
passed it and it went out to the states for ratification.
We have
it
at
would
least
take
20, I don't know,
3/4.
27, 28.
So that's just a little over half.
Yeah.
And if we were to try an equal rights
Three-quarters.
amendment for women's rights to make sure that that's in the letter of the law again. You know, when Sandra Day O'Connor retired, nobody said that women were going to lose the right to vote. The right to vote
Yeah.
is in the language of the Constitution. It's not interpretation. It doesn't depend on anybody's whim or wish. It's written down. And the anti-discrimination amendments didn't make it. And we should do that. We should do that. This is why it's our fault. This is why understanding the Constitution is so important for ordinary citizens, not lawyers, not law professors. It's a very dangerous idea, I think, for people to delegate the idea of understanding the Constitution to other people. This is government by the consent of the governed. We have an obligation to understand it if we're going to have a free country.
And they're not teaching it now in the schools.
No, they're
and
not. And
they're
a lot of
pulling all
people
that
who are
out.
in the schools are not that interested in freedom. They're interested in safety or.
The
they're
Common
interested-
Core is gonna help it all.
Oh, yeah.
We have a lot of work to do. We have a lot of work to do. And as I said, a lot of this is our fault. All of us. Not just
Yep.
in this room, but the whole country. And the whole country for 100 years. When was the last time someone seriously tried to amend the Constitution? It hasn't happened in decades and decades. And
See, that's
And when you talk to people, what do they say? Oh, it's reckless. It's dangerous to amend the Constitution. You hear that. Or it's too difficult to amend the Constitution. We like it the way it is. Well, how is it? The judges issue landmark decisions, and that's how we update the Constitution, with landmark decisions. And we all sit and we wait in June for the last ruling to come down to see if affirmative action is constitutional or it isn't, to see if we have gun rights or we don't, to see if we're going to have freedom of speech or we're going to have searches in our houses, or we wait for the interpretation of the latest constitutional case. This is not the deal we signed.
And then they base it on precedent,
Right.
which, oh, well, this
Except-
progressive put it, you know,
Yes,
this
except
way. and-
that when they don't, then it's a landmark decision. When they decide to reverse the precedent, it's a
Uh-huh.
landmark decision. Okay, go forward again. I don't know what happened to my spacing here. I had it right. This is President Washington telling us. This is his farewell address. He was talking to the future. We're it. We're who he was talking to. If, in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way which the Constitution designates. But let there be no change by usurpation, for though this in one instance may be the instrument of good, it is a customary weapon by which free governments are destroyed.
Yay.
George
And I
Washington.
can't have that.
No change by usurpation. What does that mean?
That means that you can't allow people to exceed their powers to
Right,
fix a
like
problem.
the judiciary.
Right. You can't let people just jump in and fix things. You can't let the president say, I have a pen and a phone, and I'm gonna fix the problem. Because even if he does fix the problem, the fix is more dangerous than the problem was.
Not legal.
Right.
Yeah.
If appropriate to bring it up now, since you brought up a constitutional convention, it terrifies me. And the reason why it terrifies me is I don't trust anyone in the present. With a media that is very manipulative, with a dumbed-down populace, I'm sorry, it appears to be the
And the voter
case.
fraud.
And it seems like judicial papal smoke is better, because at least it isn't going to be a wholesale rewrite done cleverly by the people who said, you've got to vote for it to know what's in it.
Oh.
I
vote that
never
in.
want to see a constitutional convention. Maybe in this room, sure, as a mock exercise, but I don't trust a country of 330 million people.
Well,
Well,
what
you're
you're
gonna-
arguing
20 million more
there,
coming
if
in.
you follow that to its logical conclusion, you're arguing for dictatorship.
Let the experts
Well,
run
we
it.
have a dictatorship.
I mean, if you,
No,
I understand you want to
it's-
stop short of that, but
We're
what you're
adhering.
saying is you don't trust self-government in a free country.
That's right.
It's getting to the point where I would have to say, it seems like we are ungovernable.
Oh, no.
I don't think so.
I would,
Not
I would.
on
Well, I don't wanna be a heretic.
I'm not so,
Rules not
I'm not so
govern
pessimistic
is the
as that.
issue.
I'm really not. You know, we have a system, the Constitution constrains what can be done. You know, it has checks and balances in it, and it slows everything down. And you can't just roll over people. Whereas with the judiciary, you really can, and it's a little bit, it's a little bit scary.
And I'm not proposing that. I'm talking about a constitutional convention. Are you for a constitutional convention?
Well, I believe that if we wanted to update the Constitution through the Article 5 process, that I'm not talking about throwing it out and starting again, but if we wanted to pass an amendment through the Article 5 process, rather than go find a test case the way the lawyers in the Heller case did, go find a test case and drag it through the courts and hope that it gets there, and hope that when it gets there, you've got 5-4 the right way, I think that's the reckless and dangerous system.
Yes.
A better system is to sit down with elected representatives and hammer it out and send it out to the states for ratification and hammer out the debate in 50 states, air it out. I don't think that would be dangerous. I don't think anything crazy would pass.
They already have that, they're working on that right now.
And that's, well, then that's what concerns a lot of people
We have
from
a
the
lot of
standpoint.
states that are willing to come
Is
together.
the ability for there to be trigger mechanisms or to be a manipulative process to surreptitiously put something in a very lawyerly, clever way, so that now what you think you're voting for, like a Patriot Act, actually turns out to be a peasantry act.
Too many eyes on it.
This is
Too many
exactly,
eyes
you're
on it.
doing exactly the debate that happened when the Constitution was debated to begin with. And you can see that in the Bill of Rights. The Ninth Amendment and the 10th Amendment, it's exactly what you're saying. We don't trust them. They're gonna construct it, they're gonna construe it, they're going to interpret it. We're not gonna get what we want, so lay it out. We want a Bill of Rights, and then we want something to explain that the Bill of Rights is not all the rights we have, and we want that in writing, and then we want one more to explain that the federal government can only do what the enumerated powers allow it to do. The Ninth Amendment, the 10th Amendment, and the whole Bill of Rights itself are exactly based on the concern you're expressing right there. And apparently we have to keep doing this because, you know, if they had thrown out, just hypothetically, suppose the Supreme Court decision in the Heller case had gone the other way, and they said there is no individual right to own a gun, how long would it have taken to amend the Constitution to say, and we really mean it? Yes, there is. How long? 2 months? 6 months? I think we could have gotten that through very quickly because people do intend that the Second Amendment means an individual right to own a gun. That was always how it was understood. That's still how the people of the United States understand it and want it to be. And we're running this show. We're in charge.
That's right.
Well, it
And
doesn't
to
feel like
allow
it.
the courts to reinterpret, suppose the courts interpret the Fourth Amendment to mean the government, if there's been a terrorist attack anytime in the last 10 years, the government has the power to search anybody they want, to arrest anybody they want, to hold anybody they want indefinitely. Suppose you had a series of Supreme Court decisions that said that,
He wrote an executive order giving him exactly
Yep.
that power.
Yeah.
okay? So suppose a
Same with
court,
freedom of assembly.
suppose it went to the Supreme Court and the Supreme Court upheld it. We would have to amend the Constitution to say, no, they can't, and we really mean it. And then we have to put in another one, like the 9th and 10th Amendment, and we meant what we just said. And not only did we mean what we just said, we really meant what we just said. They can't do
But
it.
in the event of martial law, where everything is mayhem, who's going to be paying attention to the Supreme Court at that point? This man is writing rules that he thinks he
But-
expects
Well,
us to
everyone's
follow.
spoken
the
enough
public-
for him
the
because
public
people
does
in
not
power for
really-
him.
I don't
So
believe
that's
the
the
public
problem.
really supports him in this. You know, I think he,
I don't think they're paying attention.
I think a lot of people are paying attention.
When you mention executive orders, what? Right.
Well, I'm not as
Uh,
pessimistic as you are.
No, I'm not
I
pessimistic.
think people feel, safe that the courts will stop him at some point, or safe that the next election will stop him. I don't think they feel as alarmed as some of you may feel. I believe that people will stop the government from the most egregious abuses, as we just saw with this FCC study.
What's happening? Nothing.
If I can understand your research and everything, are you saying that the Bill of Rights, you know, they're federal rights, but they don't apply to the states until all these things that happened in the 60s and so forth. So does that mean that you're saying that the intent of the founders when they wrote the Constitution and the Bill of Rights was to create a United States of states that are little tyrannies that can violate? I'm just a little confused by saying, like, if we have these 10 amendments and they apply to the people of the country, but they don't necessarily apply to the state's government.
Well, the
How
states-
does that?
Well, first of all, the states were first, and they all had their own Bill of Rights, or most of them did. And so they felt that they wanted to continue to have the power that they had before the Union was formed. So they were not tyrannies, and the Constitution does guarantee a Republican form of government to everybody in every state. And the 14th Amendment does require that fundamental rights, which were at the time interpreted as life, liberty, and property, it did not include social and political rights, as we saw, because the 15th Amendment gave African American former slaves the right to vote. That was not included in the 14th Amendment interpretation. The right to vote was a separate amendment. So what we saw was you have this clarity of purpose in these different amendments, and I have forgotten your question.
Was that what you're saying is that we really didn't, the states really could have,
that's right, the states,
could have had laws that said, you know, no free speech, take away your guns,
And they
all
did.
these things, and
Slavery.
some of them
right,
did.
and they
Some of them
did. But so what you're saying, so what I'm trying to understand is that, so when the founders wrote the Constitution and wrote the Bill of Rights, who were they writing it for if it wasn't for the people of all the states? And that's where the 10th Amendment comes in that says, okay, and, you know, 1 through 9, like, states, you can't touch that. Government, we won't, you know, the federal, we won't govern it.
Let me
and everything else
back
is
up.
left to
Let
the
me back
states.
up and explain federalism real quickly, because nobody's teaching it in school. Federalism is a brand new concept in American government. When our government was founded, federalism was a brand new thing, never before seen on the face of the earth. It's two governments over the same physical area, and the way they coexist is by a division of powers. So what you have is, as it was explained, the federal government has the enumerated powers, and the states have everything else. Everything else. And then they are bound by their own state constitutions and their own state Bill of Rights, and whatever the people of each state want. And one of the things that's interesting, if you're interested in these kinds of arguments and where the seams are in history, to dig into it, the Ten Commandments decisions are very interesting, because the Constitution originally did allow the states to establish a religion, the free exercise, all the rest of it. The prayer in the schools kind of decisions from the 60s, those were curtailing based on this fundamental rights, compelling reasons and fundamental rights argument. There would not be prayer in the schools, and the 10 Commandments thing is a little bit difficult, because exactly whose right is being infringed by a Ten Commandments display? It's not easy to see what the compelling reason is for having a law that removes the Ten Commandments thing. So the law is very fuzzy, and when they issue the decisions, they're all contradictory, and they're all divided, and they're not consistent from state to state. There's no actual fundamental right to be free from religious symbols.
Right.
So a law saying that you can't have the Ten Commandments doesn't really fit under the incorporation theory. So the decisions are very they're very puzzling when you read them. They don't make a lot of sense.
Are you
They're
free
all
from
fixed.
committing murder? Are you free from adultery? Are you free from lying? Are you free from stealing?
You know, it was originally just a promotion for the Cecil B. DeMille films.
No, but do you have
If I,
everything
I saw
in
the other day that
declaration
they have the 9/11 cross
Yeah.
that the atheists come out and I look at the atheist groups. They're just leftists. All there are book burning, banning folks that they're just all they want to do is
Secular.
they're just ones to
Anything with
remove
God.
all of that. And as if it were going to be harmful to be in any part of it, And of course the argument is, well, if you're going to do that one, you have to do them all. Well, 'cause they know that'll never happen, So it's an impossible deal. But I always wonder, like, if you take their argument literally, what is it harming? Like, what is the harm
Well, see,
in
there,
that?
there it is again. If there is a fundamental right to be free from religious symbols in the public space, then there goes "In God We Trust" on the currency
Yeah.
and "Under God in the Pledge" and all the rest of it. So they're not going to do that. So what are they
They
going to do?
wanna
Well, they
do
don't
that.
know what they're going to do. They don't know why they can't have Ten Commandments displays. It's just very muddled, and it's very interesting. The original Federalist scheme would have been the states can decide if they are going to allow. The states had the freedom to ban Ten Commandments displays if they wanted to, because the states weren't bound by the First Amendment. So they could close down the press if they wanted to.
I don't
Obviously, they
understand
didn't
that.
want to.
How is that possible? How is that? How is that possible that a state could say there's no free press, there's no free speech in California?
Thomas Jefferson wrote a letter to Abigail Adams that said, "We have always defended the rights of the states to restrict a free press." Thomas Jefferson wrote that. That's how they did it.
So if all 50 states decided to do that on their own,
Was it Constitution?
That was the
I don't know,
original.
what's the Constitution for then?
You
If
need
it's
to
not
understand-
if it's not a toilet
Because that's
paper
You gotta
company.
understand how the country was
No,
founded.
but
The
it's
I'm trying to
revolution-
understand.
All right, let me explain
no,
it to you in a
because
nutshell.
14th Amendment is saying like.
I'm talking about before that, 1 through 10, before we got to the 1860s.
Yeah, look,
But you see, the states were not tyrannies. The states were not tyrannies, and people did not distrust their state governments. And that's why when Madison proposed that amendment, freedom of conscience, freedom of the press, trial by jury, the states said, "Leave us alone, we're fine. We don't need any more restrictions from the new federal government than we already have." And they weren't tyrannies. The people who founded Virginia were not tyrants.
Absolutely.
So it wasn't perceived that the state governments were this threat. Madison said they were. He said the people are as likely to be threatened by the state government as the federal government, and he didn't have the votes in the Senate to get that into the Bill of Rights.
That's what I said.
I had two questions, but I want to clarify. You know, before the United States was flooded, there were the colonies, and they were protected by, Great Britain, right? They were part of Great Britain. But in every other way, they were independent, and they made their own laws and followed their own rules, right? And no one of those colonies had any kind of jurisdiction over any of the others. They were independent vis-a-vis each other. After, the British were kicked out, they had this question, all right, are we going to establish a defense organization,
Because
basically?
I think we have to refer everything to Declaration of Independence, and after Declaration of Independence come Constitution, and Constitution is saving Declaration of the Independence.
Yeah, but just to
This
understand
is when we are thinking through Declaration of Independence, and Constitution was to save everything what was in.
Right. But I just want,
This
even before we get to the philosophical issues, just want to make it clear that there was no United States before the Constitution was ratified, right? And at that point when it was ratified, even though today we have, I'm sure individually we all have different ideas about what it means to be an American and what it means to be what the United States is. Most people think of this as a unitary thing. We're all nationals, we can go anywhere we want, and yet there are localities, right? Two counterexamples. In France, there's this one central government, and there's no such thing as a state or other cities, but they have departments. So everything is a division of this one government. In the United States, we have governments which are independent of each other. In Switzerland, even despite the myths of 500 years of peace and tranquility and all that kind of nonsense, they had a lot of controversy up through the middle of the 18th century, and things finally settled down. They actually modeled themselves on the U.S. Constitution as it existed, I guess, before Patsy's 14th Amendment.
answer the
But
question, though.
I just want to understand this. Switzerland is still today, retains that model.
that's not his
And
question.
anybody who understands, the way the Swiss work, they have all this independence among cantons. They have rules that are not affected by the federal government. And at one time, several years ago, when the Soviet Union fell apart, and there was all this talk about, reshuffling nationalities in Europe and, growing of the EU, I remember reading someone from Switzerland was complaining, he was actually ruining the fact that Switzerland was, he said, nothing more than a glorified defense treaty. But so that's, from the outside, you might look at a country like Switzerland on a map and say, well, Switzerland, France, Germany, how are they different? They're still, but that doesn't necessarily mean that the people who live there see it that way.
Yeah, but
You know, there's a sense of
she
independence.
answered the
Well,
question.
Well, I
the
just want to explain
the
that today
concern
we
is
have-
very valid, because in the 20th century, we did see abuses by state governments, we did see the courts step in and rescue people from them, and we have grown up in this era of expecting that the state governments will be repressive, and the federal government will be benevolent, and the courts will be the arbiters. And this has created consequences, some good, some terrible. And when you have a situation where the courts are deciding for a school district whether they can ban the American flag on a shirt, when you have a situation where the courts are deciding all of these small details of who can be searched and when and on the streets, and they're changing police procedures. What makes them experts on police procedures?
Right.
What makes them experts on topless bars? What makes
Gives
them
them that,
experts?
right,
You know,
yeah.
why are they more expert than the legislature or the city council? We have shifted all this responsibility to the courts. And in defense of the courts, it has to be said, they can't really do this. They don't have the staff. They don't have the structure. They can only take cases that, as they're presented to them, they can't go legislating off on the trackless field of their own imagination.
Like the CBI.
They can't always do what they would like to do to fix a problem. They're stuck with the facts of the case in front of them. We have put them under too much pressure. They have too great a caseload, and it's too much pressure to put on the judiciary, which Hamilton said was the weakest, the least dangerous of
Yeah.
the three branches. It was the one that wasn't supposed to make policy. Policy belongs to the elected branches. But you are reflecting the valid concern that comes out of the civil rights era that the states would be a problem. And somebody had to step in and fix that, which, as I talked about earlier with slavery, they did. They had to fix that because they didn't have the votes in the Senate to fix it the way the Constitution said, that it had to be fixed.
I'll keep it real short. Just a challenge on the 14th Amendment. You cited case law,
Yeah.
most of which were decades afterwards, in fact, maybe even 100 years. But, you know, what is insufficient about the Privileges and Immunities Clause and the Equal Protection Clause in that amendment that fall short? And I understand case law, but that doesn't mean that, you know, what in the amendment itself is insufficient and was filled in by these judgments that were made decades later.
They didn't ban discrimination.
Well, I would say they did.
No, they didn't.
Privileges and immunities, equal protection.
Well, you know, if you go back, tell you what, where's the book?
When you say discrimination, you mean
All the footnotes, I didn't
law?
believe it either, I didn't believe it either. In the back here, footnotes,
Yeah, we need to get that.
you can get this on Amazon. I turned this into 2 ebooks. This is, the 37th Amendment is the novel. You don't need the novel. Get the one with the footnotes. It's called How the First Amendment Came to Protect Topless Dancing. It has the footnotes, it has the history, it has the bibliography, and it's updated with the Second Amendment cases and some of the other stuff. And it's.
I'll go after him.
Okay.
We need
This
to.
is not
we need
so
to.
related to the subject necessarily, but do you know, can Congress convict Lois Lerner and put her in jail?
yes.
No, they can't. No, they can't. But you know, Congress is a political animal. It's created that way. It's not a legal decision so much as it is a political decision. And this is true of a lot of things that they do, including executive privilege claims and this sort of thing. There may be no constitutional basis for an executive privilege claim, but for their own reasons, they don't want to call the president on it and make it a political issue. You know, they would rather just negotiate quietly and then go on to something else.
Well, you know, I just, mine is more of a comment than a question, but I like it because what you're saying, you've actually introduced a whole new argument here for us. This is incredible. I mean, you know, I've never heard this before until you brought it.
Me either.
But,
I didn't believe it myself.
yeah,
6
I mean-
years of research, I didn't believe it.
But I could say this though, I think that this lady was, she hit on something here, but we all kind of dismissed it. And it gets dismissed, well, not you necessarily, but we constantly dismiss this, and I just want to bring it up based on a quote. I'll start with John Adams, and he said, and we all know this is a famous quote, "We have no government armed with power capable of contending with human passions." That's a key, underlying human passions. Unbridled by morality and religion. Oh my God, I brought the words in. And then it says, avarice, ambition, revenge, or gallantry would break the strongest cords of our Constitution as a whale goes through a net. I love that. Our Constitution was made only for a moral and religious people. It is wholly inadequate to govern any other. Now, that was John Adams, our second president, one of the greatest of the founders. And I find this interesting because, and you know, my professor friend here, I love this guy, he's all right, but I have to, you know, contradict something there. The 1776 Declaration of Independence says the unanimous declaration of the 13 United States of America. It was considered the United States of America when they signed it.
And they had the Articles of
Yes.
Confederation.
And we have dismissed this document in helping us to understand the Constitution and the rights of the people. And Larry Arnn, Dr. Larry Arnn talks about it. He says it real briefly, and I'm done. He says it here, Dr. Larry Arnn in his book, I love it. The Declaration of Independence and the Constitution stand together, defining and defending the rights and liberties of the American people. We have dismissed the Declaration and natural law, and that was after Blackstone, you know, and you know, that by the, 19th century. I always get that because I know we're a century behind, but after that, we stopped interpreting it based on the laws of nature and of nature's God. That is the entire problem with society today. The laws of nature and of nature's God has been now dismissed and abandoned as far as understanding our rights and liberties and where they come from. That's why we have things like, that's why we have abortion on demand and gay marriage and all the rest of this
Why we're
stuff.
paying for it.
And we can't settle it constitutionally until we come back to that. And that is my contention. But you did great, and I love it.
I know, you're great. Thank you. Very nice.
Everybody, thank you. Thank you.
For the campaign, I'll send you invitations to events.
Susan
keep you up to
Shelley's
date.
mailing list for the campaign, do you want to, should we put it on the table?
Sure,
Back when you-
absolutely.
Do you want to mention real brief, we're running over, but your Protect Public
Yes, I'm a-
and I'll put those on the table
Okay,
as well.
I'm a candidate for the California Assembly in the 45th District, which is the West San Fernando Valley, so if you have any friends, relatives, associates.